There is a witness statement dated the 19th of September 2018. We will be relying, we just wish to mark it for identification.
My lady, I'll be objecting to the to the defense relying on the statement of my lady, the reason why I'm opposing to that is because this witness already testified. He testified as PW1. He was cross-examined. He was referred to that same statement. So my lady, he has not laid basis on why that statement is being recorded.
No, my lady, if I was to lay basis, I would be opening my hand, but nonetheless, if they so wish. My lady, when this particular witness was testifying, we did not know that there was going to come another witness who was going to say something totally different from what the first one said.
We served the statements.
It's okay, but we also do pre-trial. So, nonetheless, Your Honor, this is a court document. It is a court of record. These documents were served upon us. I do not see a reason why the defense should not be afforded the opportunity to rely on these statements themselves to mount their defense. Honestly, don't see the reason.
I have a question. You notice I've not written anything.
Yes.
Because you all went full throttle and still find out why I'm not writing. I have a question.
Yes, my lady.
Yes, you are a court of record.
Yes.
What, in your view, would you want the court to look at when it's dealing with the matter?
To look at the sorry, my lady.
Is it the testimony? And by testimony, I mean the examination in chief, the cross-examination, and the re-examination, and exhibits produced, including those marked for identification that will be produced by the defense? Or would you want the court to look at the statement, the testimony, and the statement?
We would wish the court look at both the testimony and the statement, because ordinarily what would arise at testimony is what has been written as a statement.
Mr. Omari, stop looking down. This is where we need you.
Oh, sorry, apologies.
When we are writing the judgment, would you want the court to write PW1 stated, then PW1 wrote a statement? What would you want the court to write?
My lady, when we shall be doing submissions?
Now, and it's important. What I have seen done, I don't know.
Yes.
Is that after cross-examination, which you highlight, the differences between what has been said in examination in chief and what is in the statement. It's highlighted and brought out during cross-examination. But if you produce the statement, there is no reason not to produce all the other statements, because if in every witness who comes in, there is something they have said orally which is not in the statement, what happens?
My lady, what I'm pointing to is not that she has omitted to say something.
Not that she has omitted. I know what you're pointing to,
but
and you have asked her. You have asked her, how come in your statement you did not refer to the issue of any person being beaten? That's what was read by him.
You know, I do not wish to have her statement. I'm talking about NOC's statement. Because, you know, my lady will note that in this statement, there was an indication of another third person who no longer now appears.
Yes,
that is why we are saying
it is
suspect.
Yes, Elvas.
Elvas.
Yes.
Yes, they were apparently supposed to be more than 3. And now we have reports that they were actually 3. Now there is a person called Elvas. Yes.
As alleged by Enos.
Yes.
The 2 people did not get into my house.
Yes. But now that is where I'm saying, my lady,
you
the
even
importance.
come with people to take proceedings. You even, I'm told how you use, what is that on phone? That takes proceedings in a meeting?
And transcripts.
Oh, you're lost like me. They are ahead. Yeah? Okay?
But if I may chip in.
Now you can see my dilemma.
In terms of the proceeding case, when they present the documents, they expect that we are going to be challenging these documents.
They expect?
They expect that we will be challenging those documents.
Challenging?
Yes, we will be saying, this document, you have to prove that it is correct. Now, when it is their document, and now they don't want it to appear before court, it actually now makes us worry as for the defense. Because it is their document in the first place. And they told us, this document is fine. If you write, whichever way you want to use it, we are fine with it. Then all of a sudden, when the council says that we actually now want to use it, they have a problem. Despite the fact that we also want to rely on...
beginning to persuade me.
Yes.
That if you have produced statements and you said these are the statements we are going to rely on,
yes, then
it is assumed safely that we all have the statements.
Yes. It's only the court that do not have.
Especially now you want the court to have the statements, yes, now that somebody has testified.
Yes.
That's my view. Perhaps if I may also add, like I was saying, when I think all criminal matters go for pre-trial, the first question you always ask the prosecution
ought to go for trial.
Yes.
Pre-trial.
The first question that is always asked: have you provided statements? Yes. So if we are to rely these statements as evidence, then why can't we not, or rather, why can't we rely on these statements as also defense evidence?
That's where I'm worried. How would it be a next defense whatever, yet it is a prosecution?
Because we want the
earlier, wait. And here we're just talking about law. Let's forget about that. The earlier submission made by counsel is more persuasive, that statements are provided by the prosecution to the defense, okay, in preparation for a case.
Yes.
So it is for the defense to go through, and when the witness testifies, you cross-examine. But you cannot, and you'll excuse me for using this word that I'm trying to restrain myself, you cannot hijack that now. This statement that's for the prosecution now is for the defense. And maybe I don't know too much law, but on this one I want to be guided. I prefer the route taken, because that one is protected by the law. Chomodli case and all that. We don't have to go back. Are we on the same page?
My lady, if I may just briefly.
Yes.
Because this issue arose in pre-trial. The defense the prosecution was forced to produce some of the statements, because in some of the statements they are exculpatory. Because in this matter, there were two sets of investigations. One,
can I write that or not write? Because you are reporting things I shouldn't know. Okay, I won't write. This is off the record. Explain.
Yes.
You're saying during pre-trial, what happened?
The prosecution was forced to produce some of the statements that they did not intend to produce.
Or to use.
And the reason was that some statements were exculpatory, arising from the fact that there were two sets of investigations in this matter. One conducted by IPOA and another one by the DCI. And that's why when many of the witnesses are speaking, they are talking about two sets of statements. One, as she says, there was a statement to the DCI, and in another instance, there was a statement to IPOA.
So if there was a statement or statements written through IPOA and there were statements written through DCI, when the pre-trial took off, what statements were you given?
Both sets.
So you were given both sets?
Yes.
But maybe, if I may, but we can bring you to speed.
Yeah, please do.
There are some things you need to know, that it depends on who is being accused. Reason, this is what I'm saying. This is what I'm trying to say. The information we have ordinarily could have not been in our possession. These were police officers. It is known earlier there were statements written or recorded, and the contents thereto. Secondly, another agency equally came in and wrote or took statements. Unfortunately, at some point, now that is where probably my colleague was, they now chose which statement to bring here. Then we made an application. That we need all statements. That is why we have two sets. Otherwise, they could have not produced the two sets. And most fundamentally, if there is a disparity of what each had recorded elsewhere.
Okay, so let me understand you. What you're telling the court is that this matter has been subjected to investigations by two
agencies.
Two agencies.
Yes.
And each agency conducted its investigations and had statements recorded.
Yes.
And then the decision to charge was made by one agency.
Yes. And using statements.
Wait. And that agency made the decision to prosecute based on both sets.
No.
How did they know? My lady, they can't know that.
Okay,
Hold
fine.
on. Let's first hear their position before I turn to you and ask you your position. And notice I'm not writing down.
Yeah, that one we can't tell. That one we can't. We can't tell. That one we can't
So, the one that is not contested is that there were parallel investigations by DCI and by IPOA. And each institution had statements recorded. Up to that point, we are all agreed.
Yes.
Okay. Then let me ask ODPP.
Yes, ma'am.
How many sets did you receive?
My lady, there are 2 sets.
So
That
you
is from the
received
DCI.
both sets from
Yes.
DCI
And IPOA. Yes, my lady.
And based on both,
A decision was made.
a decision was made to prosecute.
Yes, my lady.
So if we are agreed on that, as we continue with the trial, which statements are we using? Both DCI or IPOA? What are we using?
Both.
We are all using both.
Yes.
It is the state. My lady is the state who can respond to that.
No, you're also using them.
Yes.
So as you were the
As we are
witness
using both.
testify,
Yes.
what are you looking at? So
My
that I
lady-
record what is being used.
My lady, we served both statements to the defense, the DCI one and the IPOA.
one.
And it is not because we were forced as they are putting it.
Let's
We were not
forget
forced.
the
But
drama
as we
and
are-
all. I like
We were not
remaining
there.
with I like remaining
Yes.
on the issue.
Yes,
Yes. The
but
issue is, and is agreed,
Yes.
is that 2 agencies legally carried out investigations.
that is true.
All right?
Yes,
They concluded investigations and there are written statements.
yes,
All right?
yes,
And those statements found their way to ODPP, both sets.
yes,
And then, again, ODPP legally decided on the basis of 2 sets to prosecute.
that is true, my lady.
And finally, this trial is being conducted with both sets.
Yes,
Indeed.
my
Let's
lady,
agree on that because I'm right.
Yes.
Will not change goalposts from there.
Yes.
So that with that
In
background,
fact,
I can now turn to Mr. Kinyanjui on his application with that background.
yes, my lady, there is something I want to clarify.
Yes.
It is true that there are 2 sets of statement, the DCI and IPOA. But IPOA took over from DCI and completed. Because at that time when DCI were investigating, it had
so
not
there
been
were not
completed.
investigations going on parallel, it
yes.
was one after the other.
Yes, my lady. And then IPOA took over from
Okay,
DCI.
so it started with DCI.
Yes.
Then IPOA took over. And whatever was done by DCI and whatever was taken over by IPOA combined have
Yes.
now been presented
before court now.
No, not
Yes.
yet. We are not yet here.
Yes,
ODPP.
That
And that's
is
how
true.
you made your decision.
that is true, my lady.
Is that agreed?
Yes, it is.
Okay.
And if I may,
Yes.
a few minutes ago, the statement I was referring to is the DCI one. And my colleagues have referred to both the DCI and the IPOA for our able assistant to read.
Okay, first let me record the position of this matter as regards statements.
Do please.
Mr. Omari, is that the pretrial process was done and you realized that there were 2 sets of statements in this case. Mr. Ayora, you referred to the statement by?
The DCI.
By the DCI.
And Kinyanjui is using one.
And
from
Mr.
IPOA.
Kinyanjui is using the statement by
The DCI as well.
DCI.
Yes.
There is an IPOA.
And you are now referring to statements by both DCI and ODPP.
And IPOA.
And IPOA.
And IPOA.
Yes.
Apologies. So ODPP, Ms. Tung, we have 2 sets of written statements of witnesses as PW3 confirmed. The investigations were started by DCI and statements were recorded and later taken over by IPOA and completed investigations and statements were recorded. Both sets of statements were presented to ODPP and the decision to prosecute was made. both sets of statements have been given to the defense.
That's a correct position.
Okay, now with that background, you can now renew your application.
Yeah.
Okay.
My lady, I object to the marking of that document. Oh, I think we could.
Okay. Continue.
I'm
Okay.
here to lay basis.
You are. All right. You can.
Yes, my lady, my application is based on the fact that this is a witness statement that was applied to the defense. And in line with the right to a fair hearing, this court should allow the reliance of that witness statement, given that this court has an obligation to ensure that an accused person has a right to a fair trial, and that includes a right to gather information and preserve that information necessary to mount a defense. My lady, secondly, this being a statement which was already applied to us, the prosecution will not suffer any prejudice, given that it is a statement done and written in the course of legitimate investigations. Therefore, Your Honor, we will humbly request that that application be allowed.
Yes, my lady, on our part, we will be opposed to that application. And the main reason why we are opposing this application, my lady, is that the statement they intend to mark as their exhibit pertains to a witness by the name Enos Alubisi, who had already testified, who testified as PW1 on 30th of September 2025. My lady, the witness was cross-examined based on the statements that we had served the defense, and based on his testimony that he gave before this court. My lady, at that time, when that witness testified, the defense had an opportunity to mark his statement, and my lady, my objection is at the point they are bringing up the statement when this witness is being cross-examined. My lady, the witness whose statement is being referred to will not have an opportunity to explain himself to court regarding the issues they want to put to this witness. He had already been cross-examined extensively by the defense. and we will therefore suffer prejudice if the same is marked and later produced as a defense exhibit. We wouldn't have had any issue if this document had been marked when that witness testified before this court. But at this stage, my lady, we vehemently oppose to it. My lady, at the time that witness was testifying, I can confirm they had, and they have confirmed they had that statement. And I'll be praying that the said application be denied.
As I have indicated, that nobody knew what the current witness was coming to testify. Therefore, we find the submission by the prosecution to expect us to perform prophetic ties, which we cannot do. In any given legal system, my lady, the accused person has always been termed as the darling of the law, and that is for good reason. My lady, we cannot be given documents that the prosecution intends to use to ensure that the accused persons are punished according to the law under which they are arraigned, and at the same time expect us not to use the very same documents as a defense. Now, my lady will note that the law is a double-edged sword. If this court was to allow the submission by the prosecution, then in essence, my lady, we will be doing away with the need for witness statements in the future. Need I remind the prosecution, my lady, it is that the burden of proof is always on the prosecution. So much so that it is not the duty of the accused to prove their innocence. But the accused persons are enjoined by law to use whatever evidence that is going to be sufficient to mount a proper defense. And that entirely, my lady, is the object of a fair hearing.
only have one comment. It's going to 4, so I'll stop at this point. I don't know of a situation where you take a prosecution exhibit or statement and make it a defense. If that's happening, I want to know. That's number 1. Number 2, I think from what you have explained, this problem is larger than just that statement. I want all of you to think about how you want the fact of the 2 sets of statements finds its way into the trial. That's the larger picture. And number 3, I'm not able to take a statement of a witness who is not here and insert it as a defense mark for identification. So let's think of the bigger picture. What you're trying to tell the court, and I think I have heard more from the explanation you gave of the record, is that there are 2 sets. So let's look for a legal way to ensure that that finds its way into the court proceedings. Because this cannot be a defense document. I know you'll ask, why did I allow the traffic pleas? Those are public documents. You noticed when he asked, we mark for identification. The charge sheet is there. If we think there's any problem, we will ask the court that provides. So that one, there's no problem. But these are statements, they are personal. I wrote. That's different. So let us find a way to ensure that the statements that were recorded by DCI and those that were recorded by ODPP find their way in the court record. And I've used the word statements, not statement.
My lady, as you ponder that legal issue, can you retire from
Yes.
Indeed, it would be a mockery of justice if the prosecution are allowed to provide evidence before court, then we are told they are personal in nature. Reason, the moment a person reduces his statement and the same is handed over to us, it is handed over to us by the state, not that individual.
True.
Not that individual. 2, the whole sum of the judgment will be based on the evidence adduced by all those witnesses.
Agreed.
And if there is anything which was relied on by these witnesses at the trial stage of the prosecution, and it is provided to us as part of the information of which they have, then we are pleading with this court to find a reason that indeed we cannot be prevented.
I'm not preventing. I'm disagreeing with the method. You cannot take a statement by prosecution and make it a defense. If there is something of the sort, I'm willing to learn. But there is a method where you can have statements that you're taking issue with, finding their way into the judgment. And one way, just hear me, is when the IO comes. Have you ever noticed?
Yes.
Proceedings go on online until the IO comes to court. Everything is physical because that is the person you want to put to task. The person who recorded statements, collected exhibits, and did everything. That is the person you ask to produce anything and everything the prosecution has relied on and not produced.